California by Proposition, what was it?
215.
215, Proposition 215, and that was how many years ago?
That was 1996, and then in the last couple years there was SB 420, which was a Senate resolution which was supposed to basically enforce the medical marijuana law. Now, they were supposed to the state was supposed to set up a registration system, people were supposed to get ID cards, none of this has taken place. So, you know, whether or not the law has made a big difference is kind of questionable.
Right.
But one more area in the law I wanted to discuss with you about my grounds for appealing, which is really relevant to all of this, is that there's been some change in sentencing laws. And now the idea of mandatory sentencing under the federal guidelines in federal court has been declared unconstitutional. And so that's another ground that, you know, I'm trying to use, and people might out there, you know, other defendants might try to use.
What was that case?
U.S. v. Blakely was one of them involving sentencing, and then United States v. Booker. And they've basically declared these sentencing guidelines, which have, you know, a lot of people argued are somewhat draconian, not mandatory, but rather advisory. So our argument also is in this case, she was facing the idea of life because of the mandatory guidelines, and because those have been declared unconstitutional, we feel she should get the benefit of that.
Right, but her case started before that ruling.
Well, that's the problem.
So that's the problem, and generally in law you don't like to, you have to go by the laws as they were. When the crime was committed or when it went to trial? When it went to, well, when the alleged crime was committed. So what about generally, I mean in California, there are many people giving medical marijuana away now to clients. What is the state of affairs? I mean, are there still raids going on from the federal government, and does the state try to intervene at all, or warn people, or can they, or do they? What has been the reaction from the state of?
Well, they haven't really, I don't know if they've tried to warn people. I don't think they have. You know, when the federal government wants to come in, like in the Stephanie Landa case, it's usually, at least what I've seen, it's because the state has had, you know, a renegade police officer who's not, let's say, cooperating with state law, who's, you know, turning over evidence basically to the federal government. The states have, like in West Hollywood, I know, set up for a while a permit system where they were licensing certain clubs, and obviously the local police in the areas where the clubs exist, basically, you know, they have some kind of alliance, obviously, with these clubs. I don't know exactly what the nature of that is, but I know that it does exist. And so these clubs are really, obviously, they're still illegal technically under both the federal and the state law, because even the state law does not allow for large-scale distribution. You know, it does not allow for cannabis clubs per se. However,
it allows for what? An individual to grow their own
or
medical marijuana for personal use, or
for a caregiver who is designated by a patient to grow for one other person. But it doesn't really, and there is some allowance for collectives.
You would be safer if you had a prescription for medical marijuana from a medical doctor to basically grow your own medicine. That would be the safest way to do it, instead of getting it from a... Well, that's but the collectives are there that give it away, are there to protect the patients from cultivation charges, are they not?
Well, collective is different than a cannabis club. There are collectives might more fit into the definition of the law, where people would grow it all together and then, you know, just, you know, basically donate funds towards the growth of the marijuana and then take it. But in reality, that doesn't really occur as often as a club kind of environment would occur. I don't think it's a real danger, to be honest, for patients to get it from a collective. I think that's great. From a club, I mean, you know, I guess it is possible, like, if on the chance that the federal government raided that club that day, you would be facing federal prosecution. That's not likely. And it probably, given, you know, the odds, it's probably safer to probably get it from somewhere like that than to grow your own, because you can still get arrested, and that's why...
Even for one plant, you can still get arrested, even though you have a prescription
and then you're in court defending yourself against these charges, and you don't want to be there. Right. And the thing is that, I mean, that's also why I feel that the movement really needs to concentrate more on legalizing the plant, legalizing marijuana, because until that's legalized, it's always going to be probable cause when someone smells the odor of marijuana. Always going to be probable cause when the gas odometer reads a very high mark and there's an anonymous tip. And then the patient's going to be in a position to defend themselves, because the drug is illegal, and it's always, you know, provides the cops with a way to arrest them.
Right. So it is safer if you're a medical marijuana patient to get it from a club or a collective, rather than growing it yourself. And is that the reason that those exist, is to protect the patients?
Yeah.
So the people that are running these clubs and collectives then take on an additional risk themselves, as your client does.
Yes, they do. And I mean, in the end, is it? I don't know. I mean, it's more. I guess it's kind of more legal under the state law to grow it yourself. Mm-hmm. You know, but it's illegal under the federal law to grow it yourself. But the chance of the federal government finding you is probably a little bit better in a club than in your house if you're just growing one plant.
Right.
So, I don't know. I mean, in the end, it might just be safer to get it from your, you know, your old-time pot dealer on the street. To be honest, I mean.
Where? Okay. Now, what is the reaction from local law enforcement when federal law enforcement officers? I mean, does the federal government? I mean, their officers, do they have offices here in California, and then they decide I'm going to go and raid, you know, the little old lady from Pasadena's marijuana collective in Pasadena? Do they come from inside of California, or are they coming from out of state?
Well, this is actually a very interesting question, and one that we tried to actually expose in the Landa case, which is that we don't exactly know what the relationship is between the state and federal government. What I know is, like from the San Francisco situation, what happened there was the San Francisco police were not enforcing they weren't enforcing marijuana laws, basically. Mm-hmm. They were saying, you know, and they were also saying that everywhere this is a sanctuary, we're not going to arrest people, we're going to respect that they're growing medical marijuana. There were several police officers on the police force that didn't agree with that policy, and so and for whatever reason, I think, who knows, it might be bounty system, I have no idea. For whatever reason, they basically tipped off, I think, the federal government to come down on these people because the state wouldn't enforce it. And that's when it's going on.
So these people may have been actually paid. You don't know? You can't find out? You'd have to subpoena the information?
I've tried to. I mean, the first lawyers, I think, were interested in getting, actually it's very interesting with this case. The first attorneys were interested in that subject, but as part of the plea agreement, the federal government made the defendants not be able to discuss the issue of this state and federal police in their sentencing hearing. So there's obviously something strange going on. But because they were barred from discussing it as part of their plea, it barred us basically from looking into it. And I tried to subpoena the officers and ask them, but this judge wouldn't allow me to. He didn't think it was relevant to our claim. So. But the first time it also got hushed up, whatever happened in that situation. And as we all know, I mean, police departments make tons of money off forfeiture. Okay, so it wouldn't be such a stretch to think that they make money from turning over evidence, and in fact they do. I mean, there are federal guidelines that mandate that, you know, state police cooperate with them to get certain kinds of money. So
if you succeed your appeal, are you going to be able to drag all this back in?
That would be nice.
It would be nice if you could?
I think we could, definitely. But
because that would be very interesting. I mean, to find out that these people are getting paid.
Right.
To do this and find out if that's the case and bring that out into the light of day, that would be very good.
Oh, for sure. But I think the thing that we really need to start getting out the word is that this is the time that we need jury nullification on these federal cases. I mean, that's the real answer. Jurors need to know that they can, you know, not convict somebody if they believe that they don't want them to go to prison, and no one will look into that opinion. And that's what happened, you know, during civil rights era cases, you know, preceding them, and what happened during the slavery day cases. And I think that's our only way of.
And that's a traditional custom here in America, where the jurors can look at the law and decide whether or not they agree with the law and say that the person is not guilty. But a juror, though, doing that has to actually not say that he is doing it because of the law. The safe way to do that is to say not guilty. I'm unconvinced of the evidence. Of the case, no matter what, and so, but you cannot say, I don't believe in laws against marijuana, so I'm voting not guilty. You have to say, because a lot of people don't know that. Right.
And that's what I'm hoping to try to. Right now, I'm trying to think about what kind of media campaign I can use, you know, for my case. But as a lawyer, it's also, you're in a bad position because, you know, you have a lot of ethical rules that bind you with respect to going into the media.
Right. There are also rules people have been passing out. FIJA, which is an organization, Fully Informed Juries, and there's other ones that talk about jury nullification, and they have had cases where they will do a mailing to the entire jury pool in an area, and as long as you are not, as long as you are not specifically targeting, or as long as you are not accused cannot be accused of specifically targeting one case, then you're fine. But if you're standing